All right, here we go. I should be able to finish off the agreement in this short and not sweet lecture I have coming up here. There's a chance nobody will see this recording because, judging from the views on the ones I posted already, it's not very popular. So, I'm trying to get this thing to go viral. I will have an assignment for you that I'm going to email to you later today. Um, and then I think we're going to try to meet on Friday. So by Zoom. So just stay tuned. Watch your email. See what we're doing. The first issue, the big issue for today, is a little complicated and not that interesting. So it's incredibly important though. So what I need you to do is to really try to pay attention and try to understand this. Anytime there's an agreement involving almost anything, but certainly intellectual property, the person who's acquiring that intellectual property wants some guarantees that, they're getting what they're paying for, that they're not going to get sued by somebody else saying, hey, you don't own this, or you're infringing on us, or whatever it might be. So what is asked of the person who's granting rights is to make certain promises or guarantees, or what we call them in contracts, warranties. Just like a warranty you get for the blender. You buy the blender, there's a warranty saying the blender is going to work. And if not, then there's going to be some consequences to that. Well, the same thing is true here. A publisher is acquiring rights to compositions, copyrights, and wants the songwriter to warrant that there's not going to be any trouble with this agreement and with those songs. And typically, a couple of things are warranted or promised or guaranteed by the writer. One is that he has the right to enter into this agreement and to grant all these rights. So that means he's not tied to another agreement. I'm not telling you about it. It means that he hasn't disposed of any rights with respect to the songs that he might be giving you in that Schedule A. So he has the right to enter into this agreement and perform all the duties in it and give all the rights that he's giving. Secondarily, one way or another, in that paragraph, you should read through it. All paragraphs are going to look different. There's going to be some guarantee by the writer that it does not infringe on anybody else's rights and that the publisher is not going to get sued. And there could be a bunch of things. It could be copyright infringement. That's the biggest one. How often do people get sued for copyright infringement? How often do songwriters get sued for copyright infringement? Well, among successful songwriters, all the time and every time. So these provisions are going to have a substantial impact, so they have to be negotiated carefully. So the songwriter is guaranteeing that there's not going to be any kind of copyright infringement lawsuit brought against the publisher as a result of the songs that are being delivered under this agreement. But it's not just copyright. It could be anything. It could be trademark infringement. Some people have been sued, not successfully, but have been sued for trademark infringement with respect to things that they use in songs. The most popular probably case involving that was I'm a Barbie Girl. Let's all sing it now. No. But Mattel sued whoever did that, Aquaman or something, sued them for copyright, for trademark infringement. They lost, but you still get sued. You still incur costs, etc., etc. So that could happen. You could be sued for defamation. Eminem's mother sued Eminem and his record company and his publisher for defamation, for nasty things that he said about her. You could be sued for violation of someone's right of publicity or right of privacy. Those two things both came up, I think, in the Rosa Parks case, where Rosa Parks sued Outkast for using her name as the title of a song and some things within that song. Now, it wasn't really her because she was kind of old and didn't know what was going on, but it was her estate that sued for an invasion of her right of privacy or publicity. So lots and lots of lawsuits can come from can come against the publisher for various reasons, censorship, all sorts of things. So what the publisher is going to look for in a really well-written warranties section, in which this is not, is going to look for the writer to warrant that none of this stuff is going to happen. And then if something does happen, well, you're in breach of the agreement, number one, and liable for damages to the publishing company. And number two, what we call an indemnity clause is going to kick in. So the warranties were, let's just cross-reference this here. The warranties were in paragraph 5, is that right? Paragraph 5, if you want to read through that. It's really important that you read through this and read through it many, many times. And the indemnity is paragraph 15, 14, 14. Where is it? 14. Got it. Paragraph 14. So the first thing is 14a. I don't really have this on here, but it's a very important provision. And what it says is that it doesn't have to do with this necessarily. It says that if the publisher sues somebody else for copyright infringement, that is, somebody else is infringing the copyright of a song that you wrote, that they have the right, though not the obligation, maybe they should have the obligation, they have the right to go and sue that person. And that if they are victorious in suing someone and they receive some damages as a result of that, then they will split the proceeds of that judgment with the writer, according to how all the money is split under the agreement. That's very important to have in there, because remember, if that paragraph is not in there, and then you have the catch-all provision in the royalty section that says, hey, if we don't, these are all the royalties you're getting, you're not getting anything else, then it's conceivable, and it has happened a million times, especially in the record business, where you can sue someone for copyright infringement, the publisher makes some money from that, and then doesn't have to split it with the writer. So even though it was your song that was being infringed. So that's a very important paragraph that has to be in there. My dog is knocking on my door. Do you want to see my dog, my new puppy? He's huge. Maybe later. That'll keep you watching. The more important paragraph is paragraph B under section 14. And I'm just going to read it. I hate to do this. I'm just going to read it. See if you can glean the meaning. You already tried once with your summary, so this ain't nothing new. Why don't I look at the camera? Why do I look at my face? I hate looking at my face. There we go. There's the camera. Hi. Anybody watching out there? Stop talking. All right. Here we go. I'm reading. Paragraph B. Read with me, please. Read. If a claim is presented against publisher in respect to any musical composition hereunder, and because thereof publisher is jeopardized, publisher shall have the right thereafter, until said claim has been finally adjudicated or settled, to withhold any and all royalties or other sums that may be or become due with respect to such compositions, pending the final adjudication or settlement of such claim. Publisher, in addition, may withhold any and all royalties or other sums that may be due and payable to writer hereunder, an amount that publisher deems sufficient to reimburse publisher for any contemplated damages, including court costs and attorney's fees and costs resulting therefrom. Upon the final adjudication or settlement of each and every claim hereunder, all monies withheld shall then be dispersed in accordance with the final adjudication or settlement of said claim. Yikes! So, did you summarize that? Was that in your summary? Essentially what it's saying is, hey, if the publisher hears that somebody thinks your work is infringing on theirs in some way, then the publisher you are responsible for any damages that the publisher incurs as a result of that, any kind of legal fees they incur defending themselves, any kind of final judgment or settlement that they enter into with that party, and additionally, they can stop paying you royalties until such time as that claim is settled or goes away, which could be years and years and years. So this is very, very important, because how often do people get sued? I think the answer was all the time. And so this section is going to kick in, and so it's got to be very carefully negotiated. So I'm just going to highlight some of those issues for you. That's called indemnification, where somebody is indemnifying. The songwriter, just so you know where the word comes from, the songwriter is indemnifying the publisher. And indemnification is probably a word you don't use a lot, but you know, it's essentially, it's used in the field of insurance, that you're insured when you get insurance from State Farm or from Flo, the progressive lady. That insurance company is indemnifying you. And what that means is that if you get into some trouble and get in a car accident and you're on the line for paying damages to somebody, the insurance company is going to indemnify you. They're going to pay all those costs. So what this section is saying is that the songwriter is indemnifying the publisher. So the publisher gets in any trouble, is on the hook for any kind of money, legal fees, or final judgments or settlements, that the songwriter is going to pay for all of that. Yikes! And in the meantime, the publisher gets to withhold royalties. So just be aware of how this particular provision is written. It's not too bad, but it could be better. Pay attention to what's going on with withholding, what triggers. That's my horse noise, because Trigger was Roy Rogers' horse. That's before my time too, so don't give me any of that okay boomer. What triggers the withholding? And that's just them hearing about a claim. If you look at that, if any claim is made, that means somebody calls them up and say, "You're infringing me." Then they can start this withholding process. So you should have something in there that if no legal claim is filed within 6 months of hearing about this claim, then they can't withhold any royalties. All royalties have to be distributed to you. You got that? So the trigger is just them hearing about something. You got to make sure that if no legal claim is filed, that is nobody ever files a complaint in court, that stop withholding these royalties, right? Because nothing's happening with this stuff. You just heard about something. Give me my royalties. Secondly, you got to think of what they can withhold. They should only be able to withhold your royalties under this agreement. Sometimes it would be cross-collateralized with other agreements. Sometimes it will say any monies due you, so you wouldn't get any advances in that case either. I would say just any royalties under this agreement. And then it has to have this phrase, in an amount reasonably related to the claim. It has to have that in there because, I'm looking at myself again, because otherwise, they could be sued for $50,000 and they owe you $1 million in royalties. They can withhold that entire $1 million. So it's got to be in an amount. That phrase has to be in there. In an amount reasonably related to the claim. And once again, I will mark up a paragraph, just like I will for several others, and send them out to you. We'll review them over Zoom. Next, you as the writer want to participate in the defense. That is, have your counsel at that table so that you are fully confident that they are going to be defending in your best interests. Because sometimes if you're a very successful writer, there's plenty of royalties to pay this thing off. They don't really care. They don't really care. So you want to make sure that you are being defended adequately and have a lawyer at the table. So participate in the defense. It should say, I want the ability to participate in the defense. Secondly, you want to be able to consent to any settlements. This is very complicated. This is very complicated, but here we go. If a publisher is being sued for some amount of money and there's enough royalties, your royalties just sitting there, they may just want to settle this thing to have it go away. They don't care. It's not their money, so they're gonna settle this thing. I'm sorry, my phone is buzzing. I'm easily distracted, I just realized. So you don't want them just to pay your money to make something go away. So you want to be able to consent to that settlement, because it could be that you weren't infringing at all, and you want to defend this thing all the way through. Now, a publisher is going to be very apprehensive about that, is putting your consent rights in there, especially since maybe you won't be a successful writer. Maybe you have no royalties coming to you, and they're being sued for $500,000, and somebody's offering to settle this thing for $50,000, and it looks like the publisher is going to lose, and they go, "This is a great deal for us to settle for $50,000," and you're sitting next to them, going, "Nope, I don't consent to that." So if you want consent rights, this is the hard part. If you want consent rights, generally what you have to do is you have to post a bond. Like you're in jail and you're posting bail. You have to post a bond in the amount of the ultimately sued for amount. So if somebody's suing the publisher for $1 million and they offer the publisher the right to settle for $400,000 and you say no, you've got to go post a bond. That is, put $1 million somewhere so that the publisher knows there's $1 million for them to pay this thing off if they eventually lose. So just to sum that up, it's complicated how that whole thing works, is that as a writer, you want consent rights to any settlement. If you want those consent rights, generally speaking, you are going to have to post a bond in the amount of the eventual judgment, potential eventual judgment, if you want to refuse to consent to a particular settlement. Okay, that's that. How about this? Let's say the publisher gets sued for copyright infringement because of one of your songs. They litigate this whole thing, and it turns out, whoa, we win! We successfully defend ourselves from any kind of a liability, so we win. But it costs $300,000 to defend this mother. So you, under this agreement, the writer, would owe the publisher $300,000, even though you didn't do anything wrong. I don't think that's really fair. So what I would suggest is that you put an additional line into this indemnification that says, in the event that we successfully defend any case which alleges a breach of any of my warranties. Legal costs shall be split 50-50 by the publisher and the writer. Okay, understand that? Because I didn't do anything wrong, but we did incur some costs as a result of my song, so let's just split it like we split the money. Okay, and as I said in the outline, the first paragraph has to do with successfully prosecuting someone for copyright infringement and splitting the proceeds of that with the writer. It's got to be in there. All right, just a couple of miscellaneous things in here that just to be complete, to make sure we've gone over virtually every word of this agreement. And it's also important because some of these, what we call boilerplate provisions in an agreement, in this agreement, occur in every agreement and will occur in the next agreement you look at and the next agreement you look at. So just get used to reading them. Number one is assignment. Usually there is some kind of restriction about whether somebody can assign their rights and obligations under the agreement. Now in our paragraph 19 in this agreement, it says, hey, you know what? You, the writer, can't assign any of your rights or obligations, which makes sense. Publisher signed you as a writer, and then you say, hey, guess what? I just assigned, my friend Louis the obligation to deliver songs to you. That wouldn't work. So that's fair. But the publisher should not be able to stop looking at messages that come across my screen. The publisher should not be just able to assign this agreement willy-nilly. Did I just use the word willy-nilly? That is, they can't just say, oh, I've just signed this writer here and I decided I don't like him, so I'm assigning this to another publishing company, because that writer was very interested in signing with that publishing company for very specific reasons. So they shouldn't be able to do that. On the other hand, publishers, as we know, are in the business of building up catalogs and then selling them. And so they don't want any kind of restriction on their ability to get rid of your stuff when they're getting rid of their whole company. So what it should say in an assignment provision is that a publisher may only assign its rights and obligations under this agreement in connection with the sale of all or substantially all of the assets of the publisher. So they can't just cherry pick you out and sell you to somebody, but they can, in fact, sell their entire company to another publisher, their entire catalog. Does that make sense? All right. Other boilerplate stuff, you can choose your remedies in your contract. You can create your own little world. Yes, you can, because anything's possible. Who said that? Who said that? Doug Henning. So be careful. This agreement's not too bad, but agreements, you can agree to have anything happen as a result of one party breaching the agreement or not. You can decide what the penalties are going to be, and sometimes they can be onerous. Like if you're on The Bachelor or Survivor, and they make you sign this thing that says, hey, if you disclose anything that happened here, you owe us $5 million. That's what it can say, and a court will enforce that if it's reasonable. So be careful when those remedies are stipulated to or agreed to in the agreement. There's always going to be a provision for how notices are very important. Exercise of options, breach, all those kinds of things we've spoken about already. So make sure that there's a notice provision in there that provides for how notice shall be sent, and usually should be in some verifiable fashion that you can verify that somebody received that notice, and that's usually through certified or registered mail, something like that. Every agreement is going to have what we call a merger clause or an integration clause, which says that everything we've agreed to is in this agreement and there are no other agreements that we have between us. So be very mindful of that, because sometimes in the negotiation process, in the wooing process of trying to get together one party or another, here the publisher might make lots of promises to you and you're like, okay, I believe you, you're going to do that for me. If it's not in the agreement, doesn't matter what they said. Doesn't matter what they said, because this one little sentence says everything is in here. So any kind of other promises, representations, whatever, are out the window at that point. Merger or integration clause. Changes have to be in writing, so be aware of that. Just like the original document, don't let any kind of oral agreements transpire between the parties, because they will not be valid. Usually you have to give your power of attorney to the publisher so that they can take care of the business that needs to be taken care of, copyright registrations, all sorts of other things. So be careful. They are acting on your behalf. That's what power of attorney means. They have the ability to act as you. Make sure that is limited to dealings that are necessary, like registrations and other kinds of things. And then finally, this is a pretty important one too, and you'll see it in almost every agreement, is choice of law and forum or venue. And that is, in a contract, you can create your own little world, as I stated to you. And so what you can say is, hey, if we have any problem under this agreement, this is the place where you can sue. This is the only place, the only court where you can sue. And this is the law that is going to apply. So you can decide that, even though it really doesn't make intuitive sense. Maybe neither of the parties even live in that jurisdiction. You will notice that most agreements do not have California courts or California law apply, because those laws are generally more favorable to artists than they are to companies, or more favorable to artists than other jurisdictions are. Maybe you've learned in some of your other classes, there's a law in California that says you can't hold somebody to an agreement for longer than 7 years, which most recording agreements and publishing agreements turn out to be. So you'll know, I think we discussed at the beginning of this semester, Kanye West was trying to get out of his publishing agreement, which had been since 2004, 2006, and he was going to try to get out of it under the California 7-year rule, because it's been longer than 7 years according to my calculations. 2004, yeah. But that agreement had, you can only sue me, the publishing company, EMI, I think it is, you can only sue me in New York, and New York law is going to apply. And so therefore that California law does not matter at all. So please be mindful of those sort of things that you might have to agree to under those circumstances, which may seem meaningless at first, but ultimately can be very, very important in how matters are going to be resolved between the parties. As a matter of fact, you can choose not just where and what law is going to apply, but you can also choose to have alternative dispute resolution, which is often more favorable to an artist type than it is to a corporation. And so you can choose to have arbitration, which instead of going through the time and expense of litigation through the federal or state court systems, you're going to hire an arbitrator, and the arbitrator hopefully will be skilled in the subject matter, have a little bit more expertise. It'll be faster, it'll be cheaper, and that's why companies don't let you usually do that, but you can negotiate for an arbitration clause in there rather than going through the traditional court dispute resolutions. You can also choose mediation, which is good as a preliminary step to either arbitration or traditional dispute resolution, and that is hiring a mediator. It's different from an arbitrator. An arbitrator hears the case just like a regular judge would, maybe relaxed rules of evidence and stuff like that, but when it's all said and done, the arbitrator said, you win, like that, just like a judge would, judge or a jury. A mediator is not like that. A mediator says, all right, let's get together. Let me talk to you for a little bit. Let me talk to you for a little bit. Let me think about ways in which you can come together. Let me suggest some agreements for you, and then try to get you to come to some settlement between yourselves. Nothing enforced upon you, just they are trained to facilitate a dispute resolution between the parties. That's a good preliminary step to going through the other arbitration or traditional dispute resolution, because usually when you agree to something, usually ends up being fair, or people feel better about it, etc. So having that is a good, preliminary, good faith attempt to settle your differences can be quite beneficial. All right, I think that's just about everything. What you should think about is, as you watch these videos, are you watching? I know it's painful. You don't have to look at it. You can just listen to it. Pretend it's a podcast. As you listen to this stuff, go and review your notes. Make sure you're clear on everything. I'll try to do some sort of review before there's a testing element to it. But the two things that we're going to do now that all this is behind us is to go on and work out some of the math that was involved in here. Just make sure we have a handle on that. And then number two, go over how you mark up paragraphs. So I'll go over a few. I'll go over the grant of rights. I'll go over the use of name. What else? The royalties and indemnification, the breach, all the paragraphs we talked about where there were substantial changes. I'll just show you how that sort of thing would be done when you receive an agreement and send it back to someone. And in the meantime, I guess I'll open up the discussion boards for questions, or you can just email me any questions. But let's try to learn this stuff, because as soon as we get done with this, and then those two things that I mentioned, then we're just going to move on to another agreement, which I'll have out to you by the end of the week, and a lecture on that, then another agreement, an administration agreement, and I'll have a lecture on that, and then we're going to move into licensing. So we're going to start to accelerate this pace just a little bit. Let's just try to learn it, and we're going to work with each other to make this as convenient and painless as possible. Hope you're all doing well. Hope you're all staying safe. I do miss you, and hope to Zoom you someday. That didn't sound good.